There is a moment in federal courtrooms when a case fundamentally changes. It is not the reading of a verdict. It is not a ruling from the bench. It is the moment jurors realize the framework they were given no longer holds. That moment occurred yesterday afternoon. For weeks, the defense had presented a consistent narrative. The defendant, they argued, lacked direct knowledge. He relied on advisors. He trusted subordinates. Any errors that occurred were downstream mistakes, not intentional conduct. He was portrayed as a big-picture executive, distant from numbers, removed from execution. Up to that point, the government's evidence required inference, financial records, bank submissions, internal emails, strong circumstantial proof that asked jurors to connect dots about what the defendant must have known. Then prosecutors changed the posture of the case. Late in the government's presentation, a federal agent returned to the stand for what appeared to be routine follow-up. Questions about search warrants, evidence handling, chain of custody, procedural ground jurors are used to hearing. Then came one question that reframed the trial entirely. During the execution of a lawful search at the defendant's private office, had investigators recovered any electronic recording devices? The answer was yes. A digital voice recorder was located inside a desk drawer, seized pursuant to a warrant, logged, preserved. At that point, the defense moved quickly. A lengthy sidebar followed. Arguments about admissibility, relevance, and unfair prejudice. The judge reviewed the record and ruled the recording would be admitted. That ruling mattered, not because recordings are dramatic, but because of what this one contained. The agent testified that the device held multiple audio files, routine internal discussions, ordinary meetings, nothing remarkable except one file. A recording dated months earlier involving the defendant and the company's chief financial officer. Rather than summarize it, prosecutors made a request. They asked to play it, the court allowed it, and what followed was not interpretation, it was not characterization, it was the defendant's own voice. The recording opened with a discussion about financial valuation submitted to a lending institution. The CFO raised a concern. Recent appraisals had come back significantly lower than the figures reported to the bank. The defendant asked a single question, how much lower? The answer was precise. A property listed at hundreds of millions had been appraised at nearly half that amount. There was a pause. Then the defendant responded. He did not dispute the discrepancy. He did not ask for clarification. He did not suggest correction. He explained that lenders would not verify the figures. He stated the valuations needed to remain high. He instructed that the numbers stay as they were. That distinction matters. In fraud cases, knowledge is the hardest element to prove. Prosecutors usually rely on access, position, involvement, asking jurors to infer intent from context. Direct evidence of knowledge is rare. This recording eliminated inference. The defendant acknowledged the appraisals were lower. He acknowledged the submitted figures were inflated, and he explained why they should remain unchanged. That is not background, that is intent. The recording continued. When the CFO expressed concern about potential discovery, the defendant dismissed the risk. If questions arose, he said, blame the appraisers. Shift responsibility. Proceed. Then the audio ended. The courtroom did not move. From a legal standpoint, several things occurred at once. Authentication had already been established. The device was lawfully seized. The chain of custody was intact. The voices were identified. The content directly addressed the charged conduct. False statements to financial institutions, knowledge of falsity, intent to deceive. After the audio was played, the defense requested a recess. When proceedings resumed, they moved for a mistrial. The argument was not authenticity, it was prejudice. The judge denied the motion. The ruling rested on settled law. The recording was lawfully obtained. The conversation occurred in a business setting. The evidence was relevant and highly probative. At that moment, the trial entered a different phase. Once prosecutors introduced direct evidence of intent, defense options narrow quickly. Calling the defendant means cross-examination anchored to the recording. Declining to call the defendant leaves the audio unrebutted. Neither path is comfortable. This is where many observers misunderstand what matters most. It is not the shock value of the recording, it is its placement. Prosecutors waited until the defense had fully committed to its theory. Jurors spent weeks hearing that the defendant was distant, insulated, unaware. Then they heard him give instructions himself. That sequencing is deliberate. Jurors remember reversals more than gradual persuasion. They remember moments when certainty collapses. This recording forces them to reassess everything they heard before. through a new lens grounded in the defendant's own words. This is why the government chose to rest. Once prosecutors believe they have presented evidence satisfying every statutory element, additional witnesses become risk, not reward. More testimony adds variables. Simplicity favors the party with direct evidence. Here, one exhibit compresses the entire offense. False statement acknowledged, knowledge explicit, intent articulated, materiality explained in real time. That places the defense in a procedural bind. If the defendant testifies, the recording will be played again, line by line, statement by statement. Claims of misunderstanding collapse, claims of reliance evaporate, humor and exaggeration defenses become implausible. If the defendant does not testify, the jury deliberates with unrebutted admissions as the final substantive evidence. This is why defense teams often rest, not because it helps, but because it avoids making things worse. At this stage, the case is no longer about structure. It is about choice. There are broader consequences now in play. Once intentional fraud involving financial institutions is established, sentencing exposure narrows. Loss calculations solidify. Enhancements become likely. Judges are required to assess not just what happened, but how it happened. A recorded instruction to continue submitting inflated numbers signals deliberation, not accident. Persistence, not confusion. Confidence, not error. Those distinctions matter under federal guidelines. Acceptance of responsibility also comes into focus. Courts consider whether defendants acknowledged wrongdoing in a timely manner. Recorded admissions introduced at trial complicate that assessment. Another detail matters: the presence of the CFO on the recording without charges. In complex cases, that often reflects cooperation, not omission. Jurors understand that distinction. This is why such recordings are rare and decisive. They bypass interpretation. They speak for themselves. As closing arguments approach, the prosecution does not need to revisit every document. They will return to the recording. They will tell jurors they do not need to trust interpretation. They can trust what they heard. The defense will attempt reframing, context, pressure, tone. But context does not erase instruction, and tone does not negate content. At this point, the jury's question becomes simple. If the defendant knew the numbers were inflated and directed they remain inflated, what alternative explanation remains? That question does not invite speculation, it invites accountability. This is where the trial now stands, not at verdict, not at sentencing, but at the narrowest point a case can reach, where law, evidence, and choice converge. And when a defendant's own recorded words appear to satisfy every statutory element of an offense, the unresolved question becomes unavoidable. What room, if any, remains for reasonable doubt? That question now belongs to the jury.